was former Assistant U.S. Attorney David Weinstein. So 3 court appearances today, or 3 court hearings today. Explain to us what happened, because it was a little bit confusing.
2 of them pertain only to the criminal case. The 3rd one pertained to DCF's request to release these records, so as they pointed out, they wouldn't have any unclean hands or not trying to hide anything. So the first hearing was simply the judge saying, I want the defendant here. It's an essential part of the proceedings, and I want him here. You haven't waived his presence. He hasn't waived his presence. I want to see him when he's here because you're asking me to keep documents secret from the other side of the equation here. So that's what she covered in the first hearing, and she ultimately said, whatever documents they wanted to file, she found there was a sufficient reason to keep them private and not to make them public. It appears they had to do with their access to their client and who was going to be coming in to see him, perhaps a psychologist, perhaps some investigators, building their mitigating case against the death penalty. As for the other hearing, that one concerned only the records that DCF had when Cruz was an adult, when there were reports of allegations of abuse. They wanted to release those, but couldn't because the statute requires a court to give them permission. Court's given them permission. We will now see everything that was in those reports, what DCF did to address any issues or problems that had taken place, and perhaps shed some light on what the mental condition was of Cruz.
David, what is next for the defense in this case?
Well, what's next for the defense, by their own admission now, they're simply trying to save their client's life. So now they need to start building the mitigating factors that they're going to present both to the state attorney's office as well as potentially to a death penalty phase jury who has to decide whether or not they're going to vote 12-0 in favor of the death penalty. So they're going to start to assemble his psychiatric records, what medications he was on, what treatment he had received. They're going to look into what his condition was not only now as he sits there with them, but what it was prior to that. Was he competent at the time he committed the offense? Is there information available to them that perhaps would refute that? And as he sits there now, who is he? He's a 19-year-old young man. That's about what we know about him. Now we know he has some sort of attention deficit disorder. He has potentially been diagnosed as autistic. He was taking medication. What did all of those things do to his state of mind both then and now as he sits there, and is it enough to mitigate against the imposition of the death penalty?
What about the threats he had made previously? There are reports that he threatened another student. He made that threat that was flagged by the FBI, that someone flagged in South Carolina and called into the FBI saying, I want to be a professional school shooter. Do any of those previous threats play into either the defense in terms of his competency, his mental competency, or into the prosecution?
They probably play more into the prosecution because they're going to use those as aggravating factors to show that there was some pre-planning here in addition to what we already know, that he had it together enough to post those messages, to think about the future, to think about what he was doing, and that this is not an individual who lacks the capacity either at the time of the offense or now to understand what it means to potentially be subjected to the death penalty.
So he had depression, autism, ADHD, was under medication, and there's questions about, you're talking about with the death penalty, but he was still able to buy an AR-15.
Well, he went into the gun shop, he filled out the form that any of us would fill out, and the question that says on the form is, are you currently under the treatment of a mental health professional, or have you been diagnosed previously as having a mental defect? And if the answer at the time he checked it was... His answer was no, well, they then give the form to the gun store. They then run it through the system, and if there is something in, again, the system is only as good as the information that goes in. If there's information in the system, it flags it. If not, you're right, you have to accept the answers.
And that's what both sides of the gun argument want to focus on right now.
And no waiting period.
Not for purchase of a long rifle. Different story with a handgun.
David Weinstein, thank you very much for your insight.